When making an initial custody and visitation order, the court has to take into consideration the best interest of the children. In determining what's in the best interest of the children, the court has a variety of factors that it has to consider, including the health, welfare, and safety of the children, any history of abuse by one parent against the other parent, or any abuse against the children, any history of substance abuse by one parent, or possibly addiction by both parents, and whatever else is relevant to the health, welfare, and safety of the children. It's important to understand that the court has to start with the public policy that's in the children's best interest to have frequent and continuing contact with both parents unless it's not in their best interest. Legal custody refers to a parent's authority to make big decisions regarding the child's life. There's two types of legal custody: sole legal custody and joint legal custody. Sole legal custody means that only one parent has the responsibility of making decisions regarding the child's health, welfare, and safety. Joint legal custody means that either parent can make the decision unless the court order requires the parents to meet and confer before the decision is made. It's important to understand that legal custody cannot be construed to work against the primary custodian's right to exercise physical custody. In California, the law provides for either sole physical custody or joint physical custody. Sole physical custody means that the child will reside with one parent and be under that parent's supervision, subject to the court's power to order visitation. Joint physical custody means that both parents have significant amounts of time with the child. But it's important to understand that joint physical custody does not mean that both parents will have an equal timeshare with the child or children. The family court can order a party to undergo drug testing if there's been a judicial determination based on preponderance of the evidence that the party has engaged in habitual, continual, or frequent use of a controlled substance or habitual and continual abuse of alcohol. A parent who has had a positive drug test may challenge the drug test in court. And even if the court determines that there has been a positive drug test, the court cannot use the test in and of itself to deny a parent visitation or custody. The court still has to look at all of the relevant factors and may only use the positive drug test as one of those factors. The court may consider your child's preference as to which parent he or she wants to live with after taking into consideration the child's age, the child's maturity level, and the child's ability to make rational decisions. The child's age, in and of itself, is not a determinative factor for the court. Rather, the court has to take into consideration the child's maturity and ability to make rational decisions. There's no magic age with respect to when a court has to listen to a child's preference. It's important to understand that a court is going to listen to a child more when there's a request for a modification of custody than there is when there's an initial order. And the reason is that the child will have a history of living with one parent and will be able to make a more informed decision as to which parent he or she wants to live with. It's important to understand that when a parent wants to move away with the children a significant distance from the other parent, that he or she must get approval from the court or consent of the other party. The left-behind parent has an absolute right to a notice and opportunity to be heard. Therefore, if the move-away parent does not get permission from the court or consent from the other party, he or she may be subject to criminal prosecution and possibly sanctions from the family court.